Thank you very much for joining us today for Hunton Andrews Kurth's webinar on the current privacy landscape in the United States. I'm Lisa Sotto, and I head Hunton's Global Privacy and Cybersecurity practice. And I'll start by noting that we are following events in the U.S. very closely, both through our practice, where we're assisting nearly 65 clients in virtually every industry sector with their CCPA compliance projects, and also through our Center for Information Policy Leadership, which is working very closely both with Congress and the Department of Commerce in their related privacy efforts. So I am delighted to introduce our speakers for today's program. I will start it off, and then Brittany Bacon will follow. Brittany is a partner on Hunton's privacy team here in New York. Brittany's been ranked by Chambers and the Legal 500 as a top privacy lawyer, and her work includes leading numerous CCPA projects for clients. Following Brittany will be Fred Eames. Fred is a partner in Hunton's Washington, D.C. office, and he heads our government relations team. Fred has more than 20 years of experience in the area. He is intimately involved in shaping privacy and cybersecurity policy in the United States, and he's actively working with companies now in this crazy environment on privacy and data breach lobbying efforts. And following Fred will be Aaron Simpson. Aaron has more than 15 years of experience advising clients on a broad range of complex privacy and cybersecurity matters. He is well known as a top privacy lawyer both here in the U.S. and in Europe, where he spent 2 years preceding the compliance deadline for GDPR in our London office. So he's been advising clients on both GDPR and now CCPA, where he brings his international experience to advise on the CCPA. Aaron's been recognized by the Legal 500, by Chambers, and New York super lawyers. So with that, let me dive right in. Fonnie, next slide, please. So just to, for those of you who are not familiar with our practice, it may be useful to understand our perspective on the issues. We are a global team, so we're always thinking from a global perspective, and we represent clients across industry sectors, really every industry sector, so we bring that knowledge to bear for other sectors. Given that this is such a nascent area still, we always consider the policy perspective of every issue, and we're closely apprised on that angle by our Center for Information Policy Leadership, which most of you know is a privacy think tank associated with Hunton and led by Boyana Bellamy. Next slide, please. So we're going to discuss with you today the current state of affairs in the U.S. We're going to provide an update also on the California Consumer Privacy Act, which has been going through a number of proposed and we hope successful changes through amendments, and Brittany will take us through that. I think it's fair to say that the CCPA is tying everyone up in knots. We'll then go through the federal privacy landscape. Fred will talk to you about what the current efforts are and make some predictions about where the federal landscape is headed. And then we will compare, Aaron will handle the comparison of U.S. law to global privacy efforts. And of course, this is so critical in our inextricably connected and globally intertwined world. So we need to constantly be thinking from a global perspective. Next slide, please. So what is the current state of affairs in the U.S.? I think it's fair to say that we in the U.S. are currently out of step with the global landscape around data protection laws, where nearly every first world and many second and third world countries have omnibus comprehensive data protection laws in place. We still have our historical and more vestigial sectoral scheme in the U.S. At the federal level and generally at the state level as well, but for a big exception now. And of course, big changes are afoot. So beginning in around 2018, privacy law in the United States really entered into an era of rapid change. Cambridge Analytica, in my view, was a tipping point. We were already tipping, but this sort of put us over the edge. We had already started to see the beginning of a sea change in the U.S. But Cambridge Analytica helped the American public really understand for the first time in huge swaths of the American public that number one, data underpinned the free internet, and number two, that data could be manipulated and it could be used for various purposes, from the benign and beneficial uses of data to malicious uses of data to manipulate political views. This background, coupled with the momentous changes brought about by the GDPR's compliance deadline in May of 2018, created a landscape that was really ripe for legislative action in the U.S. And as we're all painfully aware, we now, for the first time in the U.S., have a general privacy law enacted in California on June 28th in the California Consumer Privacy Act. And Brittany is going to provide an update on the CCPA shortly. The CCPA certainly signals a dramatic shift in the data protection regime in the United States. Next slide, please. Given California's significant economic impact and the fact that the CCPA is now certainly the most prescriptive, and maybe one could even argue the only general privacy law in the United States, the law has helped to set the stage for a number of similar state laws and also for potential federal data privacy legislation. So this slide conveys the extraordinary level of legislative activity in the U.S. around data privacy at the state level, at the federal level, and Fred will provide details on that, and at the private sector level. The private sector has been chiming in droves to seek to influence the legislative landscape. A number of states have introduced copycat legislation that is substantially similar to the CCPA. This is very much a shifting landscape, and there's talk of Illinois' and New Jersey's bills advancing, we saw Nevada's bill signed into law at the end of May, and then a few state laws have also failed to advance. So New Mexico's bill is dead, Washington's highly touted bill is dead, and North Dakota's bill was downgraded to a legislative management study. So very, very active environment at the moment. Next slide, please. So this chart comes to us thanks to the IAPP and shows really how, and I'm not going to go through this in detail, but it shows how the state proposals vary significantly in substance. As a general matter, many of the state proposals grant individuals rights to access certain details about the personal information that a business has collected and shared about them. A number of the state proposals mirror the CCPA in granting consumers a right to request that a business delete their personal information. And other laws have unique provisions that more or less closely mimic the CCPA. So, for example, in Massachusetts, that bill uses the term third-party disclosure to impose obligations similar to the CCPA's requirements regarding sale. But it also imposes more significant requirements, more onerous requirements with respect to minors between the ages of 16 and 18. The CCPA, as you all know and are struggling through, I'm sure, imposes more stringent obligations on businesses that have data regarding kids under the age of 16. In another example, one of the bills introduced in Texas would prohibit a covered business from processing personal information using automated processing unless the business first conducts a risk assessment and concludes that the automated processing is not likely to cause a substantial privacy risk. For those of you who struggled through the GDPR, that language sounds eerily familiar, I'm sure. I'm not going to talk about the federal requirements out there. I'm going to leave that to Fred. He will do a much better job than I will since he's been following so closely on the Hill. Let's move to private sector efforts, please. So here, since the passage of the CCPA, you can see that there have been a number of private sector efforts that are aimed at encouraging federal legislation that would preempt state law. That's the goal. And these efforts have taken multiple forms. Some are draft bills, some are in the form of principles or frameworks, others in the form of pointers. So as an example, the U.S. Chamber of Commerce issued in September of 2018 a set of privacy principles. And then in February of 2019, the Chamber released model legislation entitled the Federal Consumer Privacy Act. The name speaks for itself. Separately, the Center for Democracy and Technology in December of 2018 released a federal baseline privacy legislation discussion draft, so a very different type of private sector effort in this regard. And then the Center for Information Policy Leadership again issued a different type of document, different effort, issued 10 principles for a revised U.S. privacy framework. This was put out in March of 2019, and it's a white paper on the 10 principles that CIPL believes should be included in any new federal privacy framework to ensure both proper protection for consumers while also facilitating the digital economy, ensuring innovation, and also ensuring the responsible use of data. And of course, this paper puts forth a risk-based approach. So with that, I will turn to Brittany to bring us up to date on the latest CCPA issues.
Great. Thank you, Lisa. So we wanted to take some time during this session to really zero in on the California Consumer Privacy Act, take stock of where we are now and what we can all expect to be coming down the pike. As Lisa said, this has been a true game changer for U.S. privacy law. Never before have we had a law that applies across industry sectors and really affords certain rights and requirements that we historically have only seen in places like in Europe, but really have not had to deal with from a U.S. perspective. To sum up where the California Consumer Privacy Act is as it's currently drafted, the compliance deadline is January 1st, 2020, which is unfortunately right around the corner. There is a possibility that the compliance deadline will be extended beyond that as far out as July 1st, 2020, and that depends on when the California Attorney General issues the guidelines it is required to do so under the CCPA. The CCPA applies specifically to businesses, which is defined under the law to be for-profit companies that collect consumers' personal information, and I'll talk about what consumer and personal information mean in a moment, that determines the purposes and means of the processing of that consumer's PI, and that satisfies one or more of the following thresholds. The first threshold is that the business has an annual gross revenue in excess of $25 million. The other threshold is that it alone or in combination annually buys, receives for the business's commercial purposes, sells or shares for commercial purposes the personal information of 50,000 or more consumers, households, or devices. And the third threshold is that the business derives 50% or more of its annual revenues from selling consumers' personal information. Sale is also an important term that is defined under the CCPA. So as long as one or more of those three thresholds are met, then an organization would be deemed to be a business and subject to the CCPA. The CCPA applies, at least as it's currently drafted, incredibly broadly to all California consumers. Consumers means all natural persons, all residents of California. That includes employees, representatives of vendors, representatives of business partners, customers, applicants, etc., anyone who physically resides in the state. The data that it covers is also extremely broad, and it applies to personal information as defined under the law. Unlike our current typical understanding of what PI is in the U.S., which seems to be focused more on information that can be used to commit identity theft or fraud, or that is more sensitive, like financial information or social security numbers, the CCPA applies to any information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. That, as drafted, is actually broader than really any definition of PI or personal data that we've seen, including arguably in Europe. Some of the amendments I'm going to talk about will help narrow that a bit, and certainly narrow the definition of consumer, which should be useful. The CCPA does give specific examples of the types of data that would constitute PI, which is very important for organizations to understand. It really does require a bit of a mind shift from what we traditionally have believed and treated to be PI. It includes not only the traditional identifiers like name and address and social security number and email. It also includes IP address, commercial information, that includes products or services purchased, obtained, or considered, biometric information, internet or electronic network activity like browsing history and search history, geolocation data, audio, electronic, visual, thermal, olfactory, which is sense of smell or similar information, professional or employment-related information, education information, and last but not least, inferences drawn from any of the information I just described to create a profile about a consumer that reflects the consumer's preferences, characteristics, psychological trends, etc. So incredibly broad definition of PI. What does the CCPA require? So the biggest change from a compliance perspective is that now under the CCPA, California residents have certain rights. The first is the right to access their PI, specific pieces of their personal information. And again, when you think about how broad that definition was that I just read off of personal information, that can include a whole host of data that we would not typically ever envision giving to a customer of ours who probably doesn't even realize that we have this type of information about them. The other right is the right to delete their PI. There are many exemptions to this deletion requirement under the CCPA, thankfully. Things like deletion is not required if the data is necessary to comply with a legal obligation. There's also some very broad exemptions to the deletion requirement, like you can keep the data if it's required for internal uses that are compatible with the context in which the consumer provided their information in the first place. The third right is the right to opt out of the sale of PI to third parties. Unlike what we traditionally think about when we're talking about sale, this is not just limited to disclosing information in return for money. Sale includes selling, renting, releasing, disclosing, making available, which is we're interpreting it to pick up potentially information that's collected by cookies, like third-party cookies, transferring or otherwise communicating a consumer's PI by the business to another business or a third party for monetary or other valuable consideration. Unfortunately, the CCPA does not define valuable consideration, so it really does leave open the question of what exactly that means. We have looked at case law and the way other statutes have interpreted it, and at this point it seems to be quite broad. You know, would goodwill constitute valuable consideration? Would an enhanced service that would otherwise not be provided without disclosing the data to the third party? These are the kinds of questions we're wrestling with along with our clients who are really trying to understand whether any of their current practices, which typically are in the marketing and third-party context, analytics context, whether any of them actually constitute a sale, in which case the requirement is to provide an opt-out mechanism on your website. What needs to be done to comply? So we have been approaching this in sort of two phases. The first phase is to conduct due diligence and understand, take stock of what your current privacy practices are. What data do you collect, with whom you share it, how long do you retain it, what are the retention periods, etc. After conducting that diligence exercise, we conduct a gap assessment to understand what is the delta, what would need to be remediated to get the company in compliance with the CCPA. There are some pretty core compliance activities and work streams that are likely going to be required regardless of what amendments might come down the pike, which I'm going to talk about in a second. The first is to revise consumer-facing privacy policies. There's some additional requirements, content that's required to go into privacy notices. The next is to amend relevant service provider contracts. In addition to including some content that has to go into those contracts, service providers will need to certify their compliance with the CCPA. The third is to develop processes and back-end solutions for accepting, logging, responding to, and effectuating consumer requests to access, delete, or opt out of the sale of their data. And the fourth component is around role-based training, which is specifically required under the CCPA. If we could turn to the next slide. So in addition to the CCPA being incredibly confusing and conflicting in certain places, given how quickly the bill was drafted before it was introduced, there are also a number of amendments that may well change the scope and applicability and underlying requirements of the CCPA, which is incredibly frustrating understandably so, for the businesses that are trying to design compliance programs around the CCPA's requirements. I wanted to hit on a few of the kind of most important amendments, and they fall into a number of different buckets. There are about 9 amendments that are currently in progress. They've passed through the Assembly, and some of them have been sent to the Senate Rules Committee for assignment. Others have been referred to the Senate Judiciary Committee and are a little bit further along. They fall into a number of different categories. Some of them are looking to amend the defined terms under the CCPA, what has to be disclosed in the privacy policy. Some are clarifying what processing activities might be exempt from the CCPA. Others are clarifying the requirements around loyalty programs or the financial incentives programs. Others are updating requirements on how to submit consumer requests, and others are helping to limit the CCPA's ability to restrict certain disclosures and sharing of information. In most relevant part, I point you to Assembly Bill 25, which was actually introduced by Ed Chow, who is one of the authors of the CCPA. This amendment would amend the definition of consumer to exempt a person's personal information to the extent that their personal information is collected and used solely within their employee role or similar roles within the employment context. This is particularly important for companies who are otherwise exempt from the CCPA's requirements because they're able to rely on the GLB or HIPAA type exemptions under the law, and the employee data is really where their exposure is. So we are looking at this very closely, and it has been sent to the Senate Rules Committee for assignment. Assembly Bill 874 would create a clear and full public record exemption from the definition of PI. It would also clarify that PI does not include consumer information that is de-identified or aggregate consumer information. Both of those terms are defined under the CCPA, but currently all the law says about those two terms is that the CCPA doesn't restrict businesses from collecting, using, selling, or retaining de-identified or aggregate information. It does not specifically clarify that if data is de-identified or aggregate, it is not PI. So this is what the amendment would seek to do. Assembly Bill 1355 has a similar exclusion for the definition of PI that carves out de-identified or aggregate consumer information. It also clarifies that the opt-in for sale requirement for children applies only to children under the age of 16, not including those who are 16. Assembly Bill 873 proposes changes that include specifying that personal information does not cover all information that is capable of being associated with a particular or individual or household. Instead, the information has to reasonably be capable of being so associated, which is slightly helpful in narrowing that otherwise incredibly broad definition of PI. Another important amendment is around 846, Assembly Bill 846. This provides that the CCPA shall not be construed to prohibit a business from offering a different price, rate, level, or quality of goods or services to a consumer, assuming that certain criteria are met. That is necessary. This amendment is being used to address what at least on the surface appear to be conflicting provisions in the CCPA, one of which seems to prohibit flat out, the use of loyalty programs or rewards programs that allow or charge different prices or rates in exchange for data, and another part of the provision that says it's permitted if you get opt-in consent. So this would seek to clarify that, in fact, those types of programs are permitted, assuming the conditions are met. Last one to talk about is that Assembly Bill 1564. It would require businesses to make available to consumers a toll-free telephone number or an email address and a physical address for submitting requests, as opposed to what the current requirement is, which is it requires all businesses to offer a toll-free number. Online-only businesses would actually only be required to provide an email address and not a physical address. One of the bills that was withdrawn that I know was being watched very closely was around, and this was Senate Bill 561. This would have added a private right of action for all violations of the CCPA as opposed to ones connected to a security breach. So that was dead for this legislative session, and that has been met with some good news, at least from an industry perspective. Next slide. So as Lisa explained, and as Fred and Aaron will discuss further, we're in a very difficult position from a compliance perspective when you have a whole panoply of state laws that are being introduced, existing state laws that are likely to be amended, guidelines that have yet to be issued by the California AG, which are going to hopefully provide clarity on some of the more nuanced aspects of the CCPA, federal privacy bills looming, and then certainly international laws that impose additional and sometimes conflicting requirements on businesses. How do you manage that uncertainty and that disparity across the various legal regimes when you don't just operate in one state or even one country, and you have to manage it from a risk perspective? Our clients are particularly focused on trying to make some strategic scoping decisions, whether to apply the CCPA compliance programs to California residents only, or more broadly to all U.S. residents, or even more broadly to global individuals. And given the nature of the U.S. privacy landscape, we are seeing more and more companies choose to extend the requirements more broadly, or at least at the outset when they're conducting their due diligence and they're trying to define certain principles that they're going to apply on a going forward basis and build out a privacy governance program. They are applying sort of the highest common denominator standard, except where there are situations that might warrant taking a more limited and risk-based approach. Some companies are also choosing to deprioritize HR data, given, as I mentioned, the amendment to the CCPA, which would descope it. Just one word of caution around that is that there are, as you know, a number of other state bills that do not have the same exemption for employee data. So whether you deal with that data now or deprioritize it and save it for later, if those additional laws come to bear, is a question that companies are really focusing on. And I'll just end by saying, unfortunately, the timing, the compliance deadline, at least from a CCPA perspective, does not afford companies the luxury of time and the ability to wait until we see how these amendments pan out or what the guidelines say and clarify as to the CCPA's requirements. there is a need to get started now and to focus efforts on understanding where the data is, what data you have, how it's being used, with whom it's being shared. Take stock of your service providers, get that all in place and teed up so that when it is time to flip the switch and operationalize the various requirements, you'll be well positioned to do so. Next slide. This just to note, for those of you that require CLE credit, the code for this program is on the slide right now, which is 036589#2. And with that, I will turn it over to Fred.
Thank you, Brittany. Next slide, please, Bonnie. So, Congress has seen what California has enacted. They've seen other states moving. They've seen, as Lisa mentioned, Cambridge Analytica. They have seen alleged discrimination by tech platforms, and all of these things together are providing impetus for congressional action. And this is a big enough issue. I mean, we're talking about privacy regulation, comprehensive privacy regulation for the entire United States. This is a big enough issue where it is the type of bill where a member of Congress would put their name on it when it gets enacted, because this is going to be around for a long time. So they're taking it very seriously. So how are things going? What's happening in Congress? I think the first thing to mention is that bills almost always get written in Congress by the committee or committees that have jurisdiction over the subject matter. And in the Senate, the main committee that has jurisdiction is the Commerce Committee, but you've also got the Judiciary Committee and the Banking Committee that will seek to exercise jurisdiction, at least over aspects of the legislation. All three of those committees have had hearings so far. But take the Banking Committee, for example. They have jurisdiction over the Fair Credit Reporting Act and the Gramm-Leach-Bliley Act. So to the extent that the comprehensive legislation affects entities that have data regulated under those acts, they would be likely to weigh in, at least with respect to that. The Senate Commerce Committee staff is writing a bill right now, and they are responding to 6 members of Congress, 6 senators that they are calling the Big Six. 3 Republicans, full committee chairman Roger Wicker from Mississippi, and the chairman of the 2 key subcommittees, Jerry Moran from Kansas and John Thune from South Dakota. Thune is also the majority whip, and he's the former chairman of the Commerce Committee. He was chairman last year when the committee started looking at these issues. And the 3 Democrats are ranking member Maria Cantwell from Washington State, and the ranking members of the 2 key subcommittees, Brian Schatz from Hawaii and Richard Blumenthal from Connecticut. So the staff is writing a bill, and they're responding primarily to those members. There's been a heavy focus in Senate hearings so far, both in the Commerce Committee and elsewhere, on issues such as whether consumers should have the right to opt in or opt out of use of data about them. And so based on what we've heard so far, both from the hearings and from talking to various members' offices, we think the committee's draft legislation fundamentally maintains a notice and comment privacy model, what they're drafting right now. This may be comforting to some, or it may concern others that Congress isn't more fundamentally addressing privacy issues and going a little bit further. However, the committee seems very much in a negotiating mode, and they want all of the Big Six members to be on board with whatever product they come out with, and they generally want bipartisan support from within the committee. Senator Schatz has a bill that's different than a notice and consent model. It's fundamentally different, what could be called a version of an accountability model, where businesses would have duties to consumers of care, loyalty, and confidentiality. The committee likely will work in one or more of those concepts in the draft. Well, it's not likely to be a draft. When they come out with the bill, it is going to be a final bill. So when they come out with that bill, they're likely to have one or more of those Schatz concepts in there. Now, what about in the House? The key committee over there is the committee that I used to work for, the House Energy and Commerce Committee. There appears to be less rush in the House right now. We're 6 months into the year, and the committee is not yet really fully staffed up on the majority side to address this issue. And frankly, a discussion process among key members has really barely begun. Like the Senate, they want a bipartisan bill, but neither the Democrats nor Republicans yet, I would say, have a really good sense of what the other side will insist upon in legislation. Key players in energy and commerce include the full committee chairman, Frank Pallone from New Jersey, key subcommittee chairman, Jan Schakowsky of Illinois, and Mike Doyle from Pennsylvania, Anna Eshoo of the Silicon Valley area, and Republicans would include ranking member Greg Walden from Oregon and subcommittee ranking members Kathy McMorris Rogers and Bob Latta. A key for the advocacy efforts, therefore, among the business community is to keep up pressure on Congress to act, recognizing the California deadline that is looming. Next slide, please. So there are a lot of bills that have been introduced so far this year, most of them in the Senate. And we've listed a few bills on this page that are of consequence, by no means all. Remember the bills that are truly the most important, the Senate Commerce bill that's being drafted by staff right now and the eventual House Energy and Commerce bill really have yet to be written. So what's the significance of all this other legislation? Well, these bills serve as markers whereby a senator essentially is saying, you know, if you want my support, use my concepts. Use some of my concepts in this bill. They're also kind of signaling to constituencies that this is where they are, this is a position they're staking out on the issue. If a senator's on a relevant committee, the committee wants his or her vote, and they might strike a bargain by including some of the senator's bill into the committee product. If they're not on the committee that's working on the bill, it's generally less important to take their positions into account, but that's not always the case. Let's take the Markey bill that's on here, for example. Senator Markey is on the Commerce Committee, and I just picked out one particular provision that's in his bill just for illustration purposes. It's got a provision in there to require the FTC to establish a, quote, centralized internet website that lists each data broker in the United States. Now, this is a concept that former FTC Commissioner Julie Brill had pushed for a number of years. In the meetings we've had on Capitol Hill, we've been asked by some of the Big Six staff what we think of this concept. So obviously, it's something they're considering, probably as a way to address this interest by Senator Markey. And that shows the significance that comes then from a bill that's introduced by another member, even if they're, you know, not one of the six negotiating the legislation. Here's another example. Senator Rubio isn't even on the Commerce Committee or the Judiciary Committee for that matter, or banking, but he's got a bill out there, and it provides, the structure of it provides what we'll call, quote unquote, ordinary rulemaking authority under the Administrative Procedures Act to the FTC to address privacy issues. And the significance of this is that Congress years ago limited the FTC's rulemaking authority, making it very difficult for the FTC to adopt new rules. And now that we're really into this privacy issue and Congress is looking at acting, many are thinking that between Congress and the FTC, maybe it's better for the FTC to sort out privacy regulation rather than have Congress enact the wrong thing into law. So maybe it's better to give the FTC a little more rulemaking authority here. Clearly, the congressional staff writing the Senate Commerce bill are trying to figure out how much rulemaking authority to give the FTC. We've heard that in a number of meetings up there. So even though Rubio is not on any committee of jurisdiction, his bill sends a signal that at least there are some conservatives who are okay with the idea of more FTC regulatory authority on privacy. Next slide, please. So, what are some of the key factors in a federal bill? Well, I think a key trait that any bill will have to incorporate to be enacted is the following: federal preemption of state privacy laws plus reasonable enforcement in exchange for something that is quote-unquote stronger than California. We hear that all the time on Capitol Hill. Well, what does stronger than California mean? How can you be stronger than California and at the same time fix the multiple problems in the CCPA that Brittany just went through in her description? Well, one way to do that would be to address issues that the CCPA does not address. Many entities, including the Center for Information Policy Leadership here at Hunton Andrews Kurth, the Business Roundtable, for example, are promoting a legislative framework that's based on what people are calling an accountability model, where businesses would have an obligation to, for example, assess and limit any harms to consumers that would come from using data about them and weigh the harms against the benefits. That's one example of something that would have to be done under an accountability model. The CCPA doesn't have any requirements like that, so this would indeed be stronger than California, and it probably could be implemented relatively harmlessly and scaled to be administered by large and small businesses alike. So that's a concept that people have been talking about for federal legislation. I and others believe this is the basic trade that could be made in exchange for imposing obligations on businesses to be accountable for their maintenance and use of data in ways that aren't required now. With rulemaking authority of the FTC, Congress preempts state privacy law and puts in place a reasonable enforcement structure. So we'll see whether that actually comes out of this process or not. But if something like that were to take place, that could increase the protection of individual rights beyond what California has done, provide one federal privacy standard and one that is interoperable with what we've seen from the GDPR and elsewhere, rather than have here in the United States a swamp of potentially conflicting state standards. It could enhance transparency and consumer control, encourage innovation, provide for fair competition, protect our competitiveness. These are all things that we want to have come out of federal privacy law and continue the consumer benefits that come from innovation with data. But as of right now, there's really no cohesive position across industry, and Congress really can't know what businesses want unless the business community tells them. And if they're hearing a bunch of different things, then that's a recipe for getting something other than what you want. Now, the Chamber of Commerce, the U.S. Chamber, has led a lengthy multi-stakeholder process to develop the bill that Lisa mentioned that the whole business community can support, and that it's been a very helpful exercise. That's the effort, is to get a bill that the whole business community could support. It's been helpful, but the resulting bill probably, I think, is too narrow to satisfy the desire that many in Congress will have for a bill that is quote-unquote stronger than California. There isn't another cross-industry effort that has produced legislation yet that I can name at present. I know some are working on it, including us here at the firm, but time is running short. And remember also that privacy advocates, as you think about what Congress has to do, remember that privacy advocates and bloggers will be influential to whether some members of Congress are going to decide whether to vote for a bill. It's going to be important for businesses to work together with reasonable privacy advocates to show there are areas of agreement, because if it turns out that, say, the Commerce Committee comes out with a bill, even if that bill is bipartisan, if it's not received well on both ends of the spectrum, so to speak, that's going to cause complications for it. If there is broad agreement among businesses and some advocates, that's going to increase the likelihood of congressional enactment of a bill. The longer Congress waits, the more state privacy laws we may have, and that likely increases problems for business and makes it more difficult for Congress to act, because more federal legislators have to look back to what their states have done and said, gee, am I doing something that is stronger or weaker than what my state has done? Next slide, please. Well, predictions with Congress are, frankly, probably the easiest part of this job, right? Not even Congress can predict what it's going to do, so everyone understands there's a high likelihood of being wrong. But That said, we know that Senate Commerce wants to get out a bill soon. I would say likely within the next month or so. They're not intending to release a draft. They're going straight to a product that they intend to mark up, which means in layman's language they're going to amend and vote on the bill in committee. Not releasing a draft and taking comment on that draft from stakeholders means they may get some things wrong, and they may get some stronger pushback than they might if they went through a slightly lengthier process where they took some feedback on a draft. But they're worried about time, and they're worried about the California law going into effect at the beginning of next year. They hope to vote on the bill in committee before the August congressional recess. If they can get the bill out and then hold that vote, they'll consider that to be a victory. Now, what happens after that is less clear, because again, both the Senate Judiciary Committee and the Banking Committee may want in on the action. And if they do, a bill may not come to the Senate floor until late this year or early next year. And as for the House of Representatives, they're going to be watching to see what the Senate does. Part of the calculus in the House is that if the Senate doesn't get the quote-unquote stronger than California right, and they get a lot of pushback on that bill, by going last, the House has more negotiating leverage. It can withhold action and thereby withhold federal preemption to get stronger regulation on data use. As for the substance of the bill, what's going to be in it, no bill is going to pass that doesn't have federal preemption and a reasonable enforcement structure. You know, who enforces the legislation is important. What the penalty amounts are is important. Whether there's a private right of action, for example, is important. And no bill is going to pass that can't be described by members who feel the need to describe it this way as stronger than California. Finally, I think no bill is really going to be sensible unless it includes some eased rulemaking authority for the FTC. So I think that's very likely an element of the bill as well. I believe there's a strong chance that Congress does enact a bill in 2020, but I'll say that many are more pessimistic than I am on that. But the reason I'm optimistic is that both Democrats and Republicans see a benefit from enacting legislation, and the price of not enacting it is high. It's incumbent upon those who are concerned about the potential impacts on their business to make sure Congress has heard and understands just how priced that high would be. And with that, I'll turn it over to Aaron.
Thank you very much, Fred. As many of you know, these U.S. developments that we're talking about are not occurring in a vacuum. Quite to the contrary, the policy landscape globally is also undergoing significant change, and that change is happening at a rapid pace. Patient zero in many respects for these policy developments is the European Union, and we've seen a number of questions come in around the GDPR and its interaction with the CCPA, which we'll get to here. In Europe, the deliberations really around the GDPR began back in 2012 on overhauling the at that time existing data protection legislative framework, the directive. 6 years later, in 2018, the GDPR became law, and in so doing has ushered in a new wave of regulation across the globe. We've seen this influence from the European Union today in the U.S. with the discussion that we've been having about the CCPA and Fred's discussion on the potential for a new law at the federal level. I think it's fair to say that neither of these developments, consistent with Lisa's opening remarks, nor the timing would look quite like they do but for the GDPR. Beyond the U.S. and Europe, Lisa mentioned over 120 countries currently have data protection laws in place. Some of these regimes have been in place for some time, but many are newly established. Important global economies like Brazil, India, Thailand are emerging with significant data protection laws of their own. And when you look closely at these emerging laws, what you'll see is the GDPR's fingerprints all over them. In India, for example, the Indian Personal Data Protection Bill of 2018, which was introduced in July of 2018 and is still pending, it imports terms of art from the GDPR like processing and personal data into the Indian law. Instead of using terms like data controller, India uses the term data fiduciary, but like a controller or fiduciary is the business who determines the purposes and means of the data processing. Those are terms that should sound very familiar to all of you. Substantively, the law in India sets out a number of data protection principles, and these look similar to what you've seen in Europe. Principles such as fairness, purpose limitation, collection limitation, which is like data minimization in the GDPR, lawful processing, notice, data quality, storage limitation, which is like retention limitation or data retention, and accountability. Beyond these principles, the Indian law will also give data subjects many of the same rights that you see in Europe, and some that overlap with the CCPA that you've heard about today. It will also impose breach notification obligations, vendor management obligations, and in some cases require the appointment of data protection officers. Also, like Europe, the Indian law imposes potentially significant liability, including through the opportunity for data subject compensation and regulatory fines reaching 4% of turnover. In Brazil, the similarities with the GDPR are actually arguably even closer than in India. The Brazilian law, which is known colloquially as the LGPD, defines a number of high-level principles that need to be respected when you are processing personal data, including familiar principles around purpose limitation, necessity of processing, transparency, security, lawfulness. Similar to Europe and India, there's also a number of rights afforded to data subjects in Brazil, and there are substantive obligations that are imposed on organizations with respect to international data transfers, similar to the EU, maintaining records of processing, akin to Article 30 inventories in the GDPR, appointing data protection officers, and notifying data breaches to consumers and regulators. So a lot of similarities in Brazil, including from a liability perspective. There's potential for group actions and for regulatory fines of £10 million or 2% of global turnover, right? So the stakes are getting higher beyond Europe and the US as well. So while the GDPR's fingerprints can be seen in these emerging laws, each of these laws also contain unique elements born of local experience. And that should be expected, frankly, when it comes to an issue of such social importance as privacy. This is certainly true when you compare US approaches to privacy, for example, with European approaches to privacy, where cultural experience and history around data processing has been quite different, right? World War II and beyond in the European Union has left Europeans with a high degree of cynicism about large-scale data aggregation by businesses and governments. In the US, on the other hand, there's a proud First Amendment tradition with free speech protections extending into the commercial sphere. And this First Amendment tradition has created the need in the US for more nuance, in my view, as a relative matter when developing privacy laws, as they're going to certainly bear an impact on those commercial speech protections. Bonnie, can you please move to the next slide? As you've heard today, the nuance can be seen with the CCPA to some degree, especially when you compare the CCPA with the GDPR. I think that one of the questions was around preparing for the GDPR and preparing for the CCPA and sort of the overlap. And I think what you're going to find, and what you probably have found, is that there are a number of similar obligations in the CCPA and GDPR, particularly as they relate to transparency, some of the data subject rights, and vendor management obligations. But I think some of the rights in the CCPA, and Brittany touched on this, such as deletion, are somewhat watered down with exceptions, right? In US law, we also, including in the CCPA, generally don't see concepts like lawfulness that we've just heard about in India, Brazil, and in Europe, meaning there is no specific obligation in the US to have a legal basis to process personal data. Lawfulness in the US has historically been built into the transparency concept, which means that data processing can be done historically as long as it's consistent with what you've told consumers you're going to do. With the CCPA, though, we're seeing movement beyond treating privacy law as a mere extension of unfair competition law, with provisions in the CCPA now empowering individuals to make choices that could impact how your business processes their personal data, no matter what representations the company has made in its privacy notice. I think this is a really important development in the United States, and it's one to keep an eye on as other states and the federal government, as Fred pointed out, come on board with their own legislation. To sum up, what we're seeing globally India, Brazil may or may not be of importance to your particular business, but what I think is important is that what we're seeing globally is that what some might have thought just 18 months ago, including myself, about the GDPR isn't really true, and that is we can't really look at the GDPR as a regulatory fire to be put out in Europe, right? To the contrary, developments like the CCPA and emerging requirements in places like Brazil or India or Thailand or beyond make clear that the situation we find ourselves in is more akin to a global policy conflagration than a fire that can be confined to the European Union, right? And I think that from a wrap-up perspective, this emerging privacy landscape around the globe certainly creates a number of challenges for multinational organizations. Frankly, it could be dizzying. But at a high level, I hope what you've heard today about the CCPA and what some of the movements that are afoot in Washington and what we're hearing about in India and in Brazil, some of it at a high level creates significant opportunities for multinationals, primarily in the form of developing scalable privacy programs with a global reach that are based on some core principles that you've heard about today, like accountability, transparency, the ability of individuals to participate in how you process their data, whether in the form of rights or other participation mechanisms, downstream vendor management, and data security obligations. And so there's lots on everybody's plate these days from a policy perspective, but certainly there are opportunities in the convergence that we're starting to see around these core principles, I think is going to be very helpful to organizations at a high level. And with that, I'll turn it back over to Lisa.
Okay, and we're nearly out of time. I just want to reiterate a point that Aaron made, which is that the GDPR is not the be-all, end-all, and it's a very, very important regime, and it contains many of the same concepts that we're seeing globally, but local compliance is critical, and the CCPA has its own obligations, some of which are more onerous, like the inclusion of household in the definition that we've not seen before. We haven't seen that in the definition of personal information at all. So there are new and different concepts, and there is a huge need, having come through GDPR, to then take that learning, and there's a lot you can leverage from that to comply with the CCPA, which has different obligations. So very quick wrap up. I have practiced in this area for 20 years, and I never thought that we would see the current level of legal activity and societal relevance that we're now seeing. It is truly stunning to me to have observed the progression in our area of law from one of Byzantine regulatory compliance to truly front-page news. And there's no question in my mind that data privacy will be a top 10 issue in the 2020 presidential election. So with that, we will wrap up, and thank you very much for joining us.